Welcome, 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 welcome in, everyone. Welcome to Care Concierge with Care Patrol, where education is the heart of everything that we do. We're so glad to have you here today for this contact hour. We're accredited by the Alabama Board of Nursing, and we're also accredited by the Alabama Board of Social Work. And each of those accrediting bodies offers 1.0 hour for this hour. In order to receive that, you must do our evaluation. Our evaluation link is posted in the chat room, and hello to everyone saying hello. Thank you for being here. If you're new to us, thank you for joining us. If you've been with us in the past, thank you for doing that. We will not be here on Monday, January 29th, as I will be moving personally my house. So I'm sorry I have to reschedule that hour. But today we have a real treat, a returning presenter and someone that many of you have grown to enjoy hearing speak as well. Pamela Strickland will be presenting liens and mineral rights in Medicaid application processing. And that's the name of Ms. Strickland's company, Medicaid Application Processing Services. She's been doing Medicaid applications for folks for 18 years. And while I bet she would even say she hasn't seen everything, I bet she's seen a whole lot. I know she has. So we'll look forward to having her speak. Are you not, is others not, are you able to hear me now? Okay. All right. Well, let's just keep going. I'm sorry for those who couldn't hear. Pamela Strickland will be presenting liens and mineral rights for us. But in order for you to receive credit for this hour, you must do an evaluation link. And that evaluation link is, and I'll read it now for those of you who are new to us. Those of you who may not be able to see a screen, you may be doing something else while you're gaining credit for this hour, or it may be on your phone and the screen is very hard to see. Let me read for you so you can make note of it, the evaluation link. And please remember that the evaluation link is password protected. We give the password at the end of today's hour, and you must do the evaluation in order to receive credit from the boards of nursing and of social work. Nurses, we will post your hour for you. Please give us 7 to 10 days, unless it is an emergency for you if you're right about to renew, and let me know. But otherwise, please give us time to post that. But we will post that for you on the ABN website, and everyone who does an evaluation will receive a certificate. The evaluation link is https://www.surveymonkey.com/r/ all uppercase letters FLY9, T as in Tom, S as in Sally, Z as in Zoo. That's our evaluation link. Please make note of it. We'll post it again at the end of the hour, along with the password, which you must have in order to do the evaluation. We do it in this way with the password because that allows us to say to the Board of Social Work that you social workers are participating in a live or classroom hour and not just simply a recorded hour. So that's why we do our evaluation the way we do. We thank you for being here. And I know that I just want to say this, whenever we do these, I always feel that they're better when you participate, when you add your experiences and observations and your outcomes and your resources to others on this line. There are many people here who will benefit from what you have to say. And I know that Ms. Strickland would love to have your questions and would love for this to be interactive. And without further ado, Ms. Strickland, thank you so much again for being here. And please share this bit of wisdom with us.
Thank you. I love being here. And the last time that I presented before you guys, we had a small discussion about liens and mineral rights, and you guys wanted to know more. So I thought this one would be a good time for us to go through that and kind of explain what that entails in the state of Alabama. So what we have here is the liens and mineral rights for the state and how Medicaid deals with those. So we will go into the first thing we have to do is find out, how would you find out if there's a lien against your property? Well, if you're dealing with Medicaid, Medicaid takes a look at each property held in the claimant's name. So John Doe is going to be a claimant. Medicaid researches his property that is owned and it has his name on it. And from that, Medicaid can tell if there are any liens on the property. And they do that because they want to have the first lien holder position. So no matter who has filed liens against the property of the claimant, when Medicaid files their lien, they get a first right in that, which means their lien will be paid before anyone else's lien will be paid. In each state, each lien is recorded in the county where the property is located. And you can contact the probate court records in that county and request a copy. And most of the time, a family member can actually go up to the courthouse, to the records department, and they will give them a copy of the lien. So you'll have a great piece of paper there in your hand so that you can see. So Medicaid is a first right to lien holder. Let's talk about when Medicaid becomes a lien holder. They will file a lien against the home of the Medicaid claimant. If the Medicaid claimant is single and there's no spouse and that claimant lives in a nursing facility, they'll go ahead and file a lien against the home and they'll request that the home be sold. There can be a child or a caregiver living in the home, and that just means that this person lived with the claimant for 3 to 5 years beforehand, and this is the only place they have to live. That they'll have you fill out paperwork about that, and that in that instance they'll still file the lien, but you don't have to sell immediately. That person can stay in the home, not a grandchild, or anything like that, not an in-law, but the caregiver or direct caregiver is a child or parent. Now, if the claimant is the spouse, has a spouse, that's called the community spouse. And the community spouse can live in the home as long as they want. Yes, there will be filed a lien against the home, but Medicaid's not going to come after the spouse and say you have to sell. They can keep that home for as long as they live in it. They can continue living in the home without any interruption from Medicaid. Now, once the community spouse dies or they decide to sell the property, Medicaid will enforce that lien at that time. And what does that mean? Let's first talk about the death of a spouse. That must immediately be reported to Medicaid, and the residence must be sold at that time for fair market value. If there's an issue with the fair market value of the home, let's say it hasn't been taken care of, and it will not sell for the fair market value as the tax assessor's office has it listed, an appraisal would be required. They would come in and appraise the home as it sits now, and they'll take pictures, do a huge report, and we submit that report to Medicaid and explain to them why that home must be sold for under fair market value. Medicaid will review that, and a lot of times they accept that appraisal, and they will accept that amount that the house will be sold for. Now, there's another way that that can be handled, in that the Board of Equalization can be called to come out to revalue the home. And that's the Board of Equalization in the county in which the house is located. And a loved one can call that number, have them come out and revalue the home at that time. And normally they will lower the value of the home quite a bit at that point, especially when they know you're dealing with Medicaid. It's a very fair way of getting that done if you don't have the money to pay for an appraisal, but that does take longer. So if we're going to sell the residence and there's no one living in it, you have to first have a bone.
Ms. Strickland, we have a question from Kimberly
Sure.
Brown. How long can the child parents stay in the home? I think you may have already touched on that, but just
They can
again.
live there as long as they want to live there. It's their home at that point. Until they get ready to leave.
Her question continues, I'm sorry. Does it
Mhm.
make a difference if the patient's home was placed in another child's name under the 5-year look back? Say it's been 4 years, no patient needs LTC.
If it's within that 5-year period, there will be a huge penalty by Medicaid. If the child did not pay fair market value for the home to the parent, they will be penalized for the amount of the home, which means in Alabama, the state divisor is $6,800 per month for a divisor penalty. So let's say the house is worth $100,000. They're going to penalize the claimant, the elderly person, by dividing $6,800 into the $100,000. That gives them a number of months. And that's the amount of the penalty, which means they have to private pay for that amount of time before Medicaid will pick up and start paying for their care. So if it's out of the 5-year range, it doesn't make any difference. But within the 5-year range, they cannot give a home away. They can't give it to a child. Now, if it's a spousal transaction, that's totally different. Spouses can quitclaim the house to each other without any problem whatsoever, but they cannot do it with children. Children must pay the fair market value. Does that answer the question?
Well, she added on, it's a different child. One is now on the property. The other child is the primary caregiver.
Yeah, the situation remains the same, that they gave the house to a child, so that's a penalty. And the other child on the property will have to sell the home. The caregiver who stayed in the home for 2 or 3 years and helped, they will need to provide evidence that they were there, that they provided that care. So that's how that works. And it's up to Medicaid completely if they accept that evidence or not.
We have 2 more questions. Ms. Powell asked 3. Can the home be transferred to a disabled child living in the home?
Yes.
And Ms. Rivera says, does Medicaid only keep the amount necessary to pay back cost or the whole home value?
Just the value of the amount paid on behalf of the claimant.
So, okay. And that
So
would
if
be
they paid
the
$30,000, they get $30,000 back.
Okay. All right. Okay. That's it. Thank you so
Okay,
much.
sure. In selling the home, the first thing you have to do is get a bona fide contract with a realtor. And that means that the realtor, first of all, needs to be really familiar with Medicaid rules. And there's a lot of realtors out there that deal with this all the time. And they will go in and say, well, we can't get fair market value. And at that point, that's when you would get a realtor. So you would get a bona fide contract, and then you would go out and get someone to come in and to assess the home, for the appraisal. And then you'll get the appraisal done by a bona fide appraisal company. And those 2 documents are then submitted to Medicaid and said, this is the home. This is why we can't sell it at fair market value. And then Medicaid will let you know if they'll accept that sale value. Because the person is on Medicaid, Medicaid has to approve the sales contract and the appraisal. I've never had them disapprove an appraisal. And a lot of times they will accept the realtor's number if they have pictures to back it up inside the home, and they have a bona fide contractor agreement, how much it will cost to fix the home to get it to the fair market value. I've had that approved twice. I've also had that denied once. So the best thing to do would be to get the appraisal done. So we would present that to Medicaid, and they said, yes, you can sell the home for that. And then at that point, if there is a contract on the home, if there's, you've got 3 or 4 people who want to buy the home, I assume that they would pick the highest and then sell the home for that amount. Then what will happen is Medicaid will send an affidavit to Montgomery and ask them, how much do you spend on the claimant's behalf? And Medicaid would send that affidavit back to Medicaid, Jefferson County, Shelby County, wherever it is, and say, this is how much was spent on the claimant. Then Medicaid would send that to whomever is filing the Medicaid or is handling this on their behalf. It would be me if I was handling it. And then I would make sure that got to the closing agent. And Medicaid becomes a line item on the settlement statement. So that means that this lien would be paid from the proceeds of the closing, and the remainder of the proceeds would be paid to the estate as per the will. So that's how, if the claimant has died or the community spouse has died, that's how that's handled. Any questions about that? Okay, we'll move on. Now let's just say that the community spouse decides to sell the house because it's too large for them and they're going to downsize. The same thing happens if this happens. That means Medicaid requires the same documentation. If they are going to just sell the house outright and they can get above fair market value, the only thing they'll need to do is get sign a realtor agreement and have a realtor, and we'll supply that realtor agreement with Medicaid, and they'll accept that. And then you've got however long it takes to sell a house, you've got that long. I've had houses sell a year later. I've had houses sell 6 weeks later. So, Medicaid's not going to be on your back about, is it sold, is it sold, is it sold? But once you get a contract on the home, that's when we must send that contract to Medicaid to get approved, even if it's above fair market value. And then we go through the exact same process with them sending that to Medicaid. They get the affidavit, and then it comes back. There is a final amount for the lien at that point, and the community spouse will receive the remainder of the sales proceeds from the residents. And so we would still send it over to the closing agent, whether that be an attorney or a title company, and they would put Medicaid as a line item on the settlement statement, and they would be paid, and the check would be sent to Medicaid Montgomery from the agent, and then we move on with the sale of the house. It's that simple. They will not take any more than what they've paid. A lot of times the lien on the house is for 50% of what the house really stands for, because they're only put a lien against the house on the claimant's amount. So he owns 50 or she owns 50%, they'll take the money from that 50%. If they pay $200,000 in fees and unfortunately your house sells for 150, well then Medicaid's going to get all their money back, and there'll be nothing left for the community spouse at that time. I've never had that happen, but that's just how that works, and that can happen. If you just need to clear a lien, let's say that you're not going to sell the house and you're going to live there, but you don't want a lien there at all. At any time in the state of Alabama, an individual can clear that lien just by paying it. And they can contact the county in which the lien is filed or which they live and say, how much is the lien for? The county can tell them what the lien was filed for. And then you can go down and pay that lien. And that's anything but Medicaid. If someone puts a lien against you for a bill that wasn't paid or anything like that, you can clear that lien simply by paying it. But even if you have other liens, Medicaid will always be the first place lien holder. So they will always get paid back first. So that's how the lien works in the state of Alabama. It's kind of cut and dried, and it's not something that a lot of people have to deal with, but community spouses have to deal with it every time we file.
I'm sorry.
Sure.
This is my question.
Uh-huh.
So if I'm understanding you, when folks ask, hey, will Medicaid take the house? I mean, the answer ultimately is Medicaid will place a lien, but you, whomever has an interest in the house, could actually pay the lien and keep the house. Is that what you're saying?
Absolutely.
Okay. Wow.
And I've had people do that from the Alabama Family Trust. Let's say that the claimant died. Alabama Family Trust at that point freezes the trust, and they send the affidavit to Montgomery. How much did you pay on their behalf? Let's say that they paid $30,000 on behalf, but there's only $20,000 in the Alabama Family Trust. Well, Medicaid's going to get that $20,000, and then the lien will only be for $10,000. And so at that point, that lien can sit there until they decide to sell the home. It may be 30 years down the road, and then Medicaid will collect the $10,000 that's left over. If there's more than enough in the Alabama Family Trust, they'll pay the Medicaid back, and there'll be no lien left on the property. So that's how that can be paid early if you don't have the ability to pay it yourself.
Thank you.
Okay, and let's talk about mineral rights. So the state of Alabama is ranked 10th nationally in the production of natural gas and 15th in the production of liquid hydrocarbons. So the annual gas production from the Alabama state waters mineral rights has ranged between 150 and 200 billion cubic feet, which is approximately 50% of the state's total gas production. And production of coal bed methane mineral rights ranges between 116 and 120 billion cubic feet annually. Now, the reason I'm telling you this is because there's a lot of mineral rights in the state of Alabama. And a lot of people don't even know that they have any type of gas or coal on their land because it's just never been researched. So people want to know, do I have mineral rights on my land? Do I own them? And the only way you can find out if you have mineral rights, if you own them, is to have a title company do a title search. And what they do, they trace the title and the mineral rights from the very first deed ever recorded on that land, could be in the 1800s, all the way forward to today. And they track where the mineral rights went and if they were sold at any time, or if there are mineral rights that are now owned. So that's how you figure out, do I have mineral rights on my land? Then once you find out that you do, the two major mineral rights in the state of Alabama are oil and gas. Now, there's no way you can know if you have either of these without talking to a professional company, a drilling company that will come out and drill on your land, or two, there's what they're called landmen. And landmen are, they work for oil companies and gas companies, and they're at the courthouse a lot of times. They're going through maps, seeing where the oil and gas and coal beds are in the state of Alabama. And they do this in every state. And you can go to the courthouse and you go to the mapping section, and you can ask them, is there a landman here? And they're very talkative. Most of the time they say, yeah, I'm here. What do you need? And you can tell them where you live, where your land is, and that you own mineral rights, and they'll look at the map and say, no, you don't have anything on your property that anybody would be interested in drilling in. Or they may say you do have something worth drilling in. So they will come out at that point if you do have them, and you'll sign. Now, it's very important before you sign anything, or anyone signs anything for oil rights or gas rights or any type of mineral rights on your property, that you make sure you have a proper attorney, an oil rights or a land, any type of an attorney that deals with minerals, oil, gas, any of that. You will need an attorney to review all the paperwork that they will get you to sign before you sign it. Do not sign it the day that it's given to you. You're going to want that reviewed, because in that paperwork, it can say that you'll get no profit from that, and you'll sign it and won't even know it, or your income derived from that could be very low. And so attorneys know what to look for, and they can guide you and say, no, we'll need to rewrite this section, and then they will talk with the oil and gas company, and then we'll pound out a contract that the family can use and will be gracious to them. So it's very important that you just don't sign anything. Talking about Medicaid and what they look at, just to let you know, in the state of Alabama, the major oil and gas fields in Alabama are Big Canoe Creek Field, Black Warrior Basin, and Citronelle Field. These fields started being drilled in 1894, and as of 2005, over $2.4 billion worth of oil and gas has been produced from those fields. And there are other types of minerals in the state of Alabama. You've got, of course, coal beds, and there are usually coal mines associated with that. And so if your property has coal mines under it, that too is part of a mineral release that you can talk with Drummond Coal or any other coal mine who would like to come in and see, is there enough for there to be digging about? And then at that point, you would really want to have an attorney on your side to fight for your rights, for those coal rights, and for the pay that you would get from that. The oil and gas companies that are active in Alabama are Bishop Petroleum, Black Rock Operating, Chesapeake, Defi Oil, Denbury Onshore, El Paso E&P Company, Energen Resources, Exxon Mobil, Midrock Operating Company, and Union Oil of California. And any of those would be who you would talk to about coming out and drilling or looking on your property for any of those things. And you always hear the stories about somebody struck gold on their property because they found oil or they found gas, natural gas. And I promise you, they did not do that on their own. They had an attorney on their side, and the drilling was done through cooperation with the homeowner, the landowner, and the company, because you don't want your land destroyed. But once they start drilling, they pretty much have the right to continue drilling on and on and on until they exhaust, if ever, that mineral right. So any income that is derived from this drilling or these mineral rights, you have to report that to Medicaid in a Medicaid application. And I've had land timber rights that I've reported, and the people were getting around $450,000 every 6 to 7 years for timber cutting. And of course, Medicaid would not approve them. So you have to be careful with that. We even put the money into the Alabama Family Trust, and every time that timber is cut, that check has to be written to the Alabama Family Trust, cannot be made payable to the family, because that property was owned by the father who is in the nursing home and who is on Medicaid. So you have to be very careful if you've got elderly people in your home that you're thinking about filing Medicaid for, and you're trying to see if there are any type of mineral rights or timber rights on your property. You've got to plan. You've got to plan. Now, Medicaid could deny approval of the claimant as they're receiving income from these oil, gas, and mineral rights, depending upon the amount of income derived. I had a mineral rights case where they were getting $150 a month as income on a gas mineral right that they had. And Medicaid just considered that income. It was a stream of income. They got it every month. And they just paid that to the nursing home. They weren't turned down from Medicaid because of that. So each instance is different. We have to be very careful with what we present and the backup that we put with it. We have to put a copy of the contract, and we also have to put proof over the past 5 years, basically, that this is what they've gotten on a steady rate. And it can go up and down a little bit, but it has to stay within a certain range.
I have a question.
Uh-huh.
It's from Miss Francisca, who asked, what if the family didn't pay the taxes and the property is lost to the state first?
Yeah, that's unfortunately, that's a problem. I've got that right now with a client who has whose parents had bought tons of land and now had these little small shacks on them, and they would fix them up and then they just run them out lease to buy. And there were a couple of them that they just let the state take back for taxes, and Medicaid has said that doesn't do it. They have to redeem that property, they have to pay those taxes, and then that house has to be sold for fair market value. So if the back taxes are $17,000 and it's going to go up on the courthouse steps, and someone pays $17,000, the family still owes whatever the fair market value is, and they'll get a penalty between the $17,000 that was paid for that, for whatever the fair market value is. If it's $100,000, and then there's $72,000 in penalties that the family's going to have, and how they're going to pay for that. And so it's best for the family to redeem the property by paying the back taxes, and not let someone else buy them, and sell the property at that time. And if you have to get an appraisal that says it's not worth $50,000, then you do that, and Medicaid will accept that, and you can sell the property for that. But this case that I have right now had 17 different lease to buy properties. 5 of them we're working on, and I'm going into my 2nd year with this case.
Wow.
I'm trying to get it approved.
Wow.
It's very difficult, very difficult. Medicaid does not budge on that.
That's distressing. Miss Taylor's asking, what if the home is left to someone in a will? Will that person have to pay the balance owed to Medicaid?
If it passes per the estate, let's see, I had one of the, I only had 2 that happened twice, and no, family never has to pay. It's always the estate of the claimant, which means the state, the Medicaid or the recovery services will look at bank accounts at that time. They'll look at anything they own at that time. If it passed through probate, it can pass legally through probate. But if he dies intestate, that house will have to be sold, and then what was paid to Medicaid will have to be paid back. When the property sells, that's when that lien will have to be satisfied.
Okay. And Ms. Jones says, what happens with reverse mortgages?
Great question. Reverse mortgages, Medicaid does work with those, and they understand that the way Medicaid will accept reverse mortgages is the money used for reverse mortgage must be paid for the caregiving of the individual. That means that if you do a reverse mortgage on a home for your parents, and say your father's the only one living, that money must be used for his care. And that means that his living expenses and his care expenses. If you do a reverse mortgage and you have caregivers come in the home, that's part of caregiving. You can do that. You can pay that money with that. You can pay his power with it. You can pay his all of that with it. But it must be for his care. It can't be for daughter's care or son's care. So they look at that, and we have to provide them with bona fide receipts. And if it is sitters coming in the home, we have to have affidavits from the sitters. So you better pay them with check. You can't pay them with cash. That doesn't swing with Medicaid. So you pay with cash, I'm sorry, you pay with check, and you note on the check what it's for, and you keep good records. And that's when Medicaid will accept reverse mortgages. If it's a married couple, the community spouse has to show where she paid for the care of the husband or the wife, and the remainder's their money and it's for their living. And we just have to show that, and that's usually accepted too.
One more question. Ms. Hornsby, what happens if the property is in a life estate?
Well, if it's in a life estate, that means that they can live there for their life until they die. And that property is held by a son or a daughter or whatever, and they can live there for the rest of their life. So the life estate itself is figured upon age. So if I don't have my notebook with me with all my numbers, but let's say the claimant is 95 years old and that claimant dies and has a life estate. The number is minuscule for a 97-year-old about how much they actually own of the estate. And that is figured, and that amount alone is what is paid back to Medicaid. And their percentage at that age that the life estate was given to them also is reflective in any mineral rights that they have, which means if they do this at the age of 96 and let's say it's less than a 0.3% ownership, you can see that it's a small amount that they would need to pay to Medicaid at that point. But life estates are figured by age. They are calculated by the Medicaid scale, and that's the amount that the life estate claimant needs to pay for their portion of the home. Hope that makes sense.
Well, I'm probably surely did to Ms. Hornsby, but for me, I'm sorry, would you educate me? A life estate, is this where you just pass your possessions while you're living, sort of like a will, but you're living?
No, a life estate is when you have a home, and let's say your mom comes to live with you, and
Okay.
she you build out a basement, you make her an entire apartment downstairs, and she wants to pay for that, and she wants some ownership in the home. Well,
Okay.
at that point, you would figure her age by the calculation, and that's how much she could pay for the home. And then you could take the money she paid you for the life estate, and you can build out that apartment using those funds to give her a
Okay.
place to live.
And Ms. Wallace says, what is there ever an instance where Medicaid does not put a lien on the home?
That's an interesting question. I have had one instance where I had both spouses in a nursing home, one 3 years after the other. They're both still living in the nursing home. And we signed all the lien paperwork. And for some reason, by the time that they both passed away, Medicaid had not filed that lien. They had the paperwork, it was signed, but they never filed it. My client son, who wanted to purchase the home, was told by Medicaid, "We're so sorry, but there's nothing we can do. We never filed the lien, so the home is free and clear. You can take the home anytime you want." So that was Medicaid's mistake. That's only happened once in all my years of doing this. And they admitted it. They never, and it, you've got to, of course, file the lien for the date of death. So Medicaid did not take first lien right, and there was no other lien against the home. So it simply passed to the son. And there was a son and a daughter, and they split it 50-50. And for far as I know, the daughter lives there, and it's on land. It's on like 5 acres.
Huh. And Ms. Straw asks, does Alabama still not consider common law marriage, or did that change again?
No. The funny thing is, common law marriage is considered for VA purposes, but not for Medicaid purposes in any shape, form, or fashion.
And Ms. McCraney asked, what if the property is in another state and the person ends up here in a nursing home?
If I file that Medicaid application I am going to file with all property. I don't care what state it's in. I'm going to file truthfully. I'm going to make sure they know. So what I can tell you is that Medicaid has a way of finding things. I've had this happen with 2 different clients who were not honest with me, and Medicaid found the issues, and they contacted me, and I contacted them, and they both admitted it. So I would always let Medicaid know of all property owned, no matter where it is. Now, there have been instances where families did not know that a parent or grandparent owned property, and it was in another state, and we filed, and I think it was 4 years later that the client came to me and said, we just received a letter from an attorney. I think it was in Colorado. Yeah, it was in Colorado, that said that my grandmother was just given a check because part of land sold in California that she was the owner of, and we had no idea. There were 6 siblings, and she was 1/6 of that. But the check was $800,000. And I said, whoa, well, it's okay. We didn't know. But we got to report this to Medicaid, because they're going to take what they've paid so far from that $800,000. And the rest of it, we've got to put in the Alabama Family Trust. So they're going to kick her off Medicaid. And so we did all of that. She was 96 at the time. And we did all of that. She lived to 101 before she passed away. And she still had in the Alabama Family Trust, I think, $600,000. And that went to the family. So, we, yeah, even if it's in another state, or if you didn't know, that's okay. Family members don't know everything, especially about the elderly parents who lived through the Depression. They never reported. They didn't share anything. They were very private. So we've had that happen. And as long as we were upfront and honest about it, Medicaid was okay with it. Any other questions?
That's all our questions at the moment.
Okay. Well, the last thing that I wanted to go through are what happens when you have land and you have like a house out on the land, and you're renting that house out to an individual, and then the spouse has to go into the nursing home. This has happened several times. I don't think I've ever addressed it, but I want to address it now. That is a source of income. So we have to actually report that as a source of income, because you're getting a rental on the property per month from this individual. And Medicaid doesn't really care what they're paying per month. They just have to see it coming in per month. And so they don't make you sell that or get rid of that or kick anyone out. They just say, we're going to make that a part of income, and it's added to the income stream. And if that puts the income above the income cap, which is 2742, that means that a qualified income trust will need to be opened up at that point. And the Social Security income can go into the qualified income trust, which we've talked about many times. That's just a bank account that Medicaid requires you to set up when the income cap is passed. And they require Social Security to be placed into that. And therefore, it drops the income cap to whatever is left for income. And Medicaid doesn't deem you over the income cap. Now, if the person were to move out of the home and that income were to stop for a certain amount of period of time, Medicaid won't say, oh, we're going to reduce your payment. That doesn't happen. You'll just need to rent it out as soon as you can and keep that income coming in. If you sell the home, same thing happens. It's the exact same process. That does not change. Even with that rental home on it, same thing happens. It has to be evaluated or appraised the same as the home does, and it's all sold in one big lump sum. So that's a rental home on the property. I think that what we get into most times is that you have a loved one living in that, and they don't pay rent, and they, you know, when an appraisal is done, they're going to point out that there's a property behind that, and Medicaid's going to require rent to be paid, or they're going to require that to be sold. And you don't want to sell a home on your property unless you're selling it to a loved one, and it has to be for fair market value.
We have a question from Miss Dean. Are QITs only recognized for SNF placement? There was discussion QIT would be accepted for home-based community services. Can you speak to this?
Well, I know that QITs are required when your income is over the income limit, and that is for skilled nursing. And I'm not sure, I don't do home waivers, but I'm told that the home waiver program requires the same income level and asset level as anything else, because you're getting Medicaid at home. You have to be considered indigent, even for the waiver program. So it would seem to me that, yes, you would need a qualified income trust if the income is over, if you're on the home waiver program, because if you're over the $2,000 in assets, you're not going to get home waiver. And if your income is above the 2742, they're going to say you're over resourced. You can't be on the waiver program. So you would need to set a QIT up for home waivers too. To my knowledge, yes.
And Ms. Maria Davis says it is the same application for home waiver and nursing home. So that's good. Thank you, Ms. Davis.
Thank you. That's good to know. I did not know that. I had one lady from the Gulf call me. She was down in Gulf of Mobile, and she asked me if I could file home waivers for her son, who was debilitated. He's a quadriplegic, but he was also a doctor of aeroscience and went to work every day. But he needed help in his home. And so I was able to get her information on the SAIL program, SAIL, and they were able to help him. So that's the only thing I've ever had to do with any type of home program. So thank you for telling me that. That's good to know.
And Ms. John says 2829 is the 2024 limit.
Thank you. I have requested that number. Is 2849?
2829.
29. I will update my board. Thank you so much.
That's a pretty significant increase. I mean, that's gone up pretty significantly since I've been doing this since 2011, and you've been doing it for 18 years. So
yeah. I knew it went up at the first of the year. I just hadn't gotten my COLA sheet yet to tell me what it is. I usually get that by the middle of the month of January.
Well, I feel like this number, as high as it is, helps a lot of people get Medicaid.
It does, because you have to understand that what we're seeing now, people going on Medicaid, especially the men, have railroad retirement, which is actually always higher than your Social Security retirement. So you see railroad retirement, and you also see those baby boomers, as we are, that actually planned for their retirement, and they have these larger retirement accounts that pay them a stream of income. And so we're seeing the income cap going up for them, and that's great, because it takes so much of a weight off of them having to take that income and split it and place it into a QIT. So that's great news. As far as the community spouse, she can still get part of the spouse's income, the claimant spouse's income, if her income is below the 2465, and I assume that's still the number. Please correct me if it's not this year, but she can get part of the income of the spouse to get her up to that amount if she falls below that amount, because Medicaid does not want the community spouse to be indigent as much as anyone else. So they let you bump that up to that amount.
Well, thank everyone for the questions. Surely there are more. We have 150 folks on with us, and Ms. Strickland, Ms. Horton, thank you. Just for clarification, does it mean that a person can have up to 2829 in their account instead of keeping the account balance under 2,000?
No, does not. The income amount is going to go right back out to nursing home. Or if you're on a community-based waivers, your income is going to go to pay for upkeep and care. So the resource amount is still $2,000 below, through 2,000 or below. You can't go above that anytime during the month. You can go above it, but they know you're going to pay your income out during the month, and so it has to be on the first day of each month below $2,000, or they will kick you off Medicaid. The income amount for those on Medicaid in a nursing home, they know that you're going to be paying any supplemental insurance that the claimant now pays, so Blue Cross Blue Shield C Plus or anything like that. And you're going to be keeping $30 a month for the Social Security amount you get to keep for the personal needs allowance. The remainder of that is going to go to the nursing home. So they know you're not going to be keeping that. That's just a stream of income that's going to go right back out. And so after you pay the insurance and after you keep that $30, everything else goes to the nursing home. Unless you have a spouse, and that spouse gets to keep a portion of that to get her income up to where she's not indigent and she can live. On waivers, that's a great question, and I wish I could answer that for you, but I cannot, since I don't do waivers. Maybe someone out there can answer that for us.
Oh, this was Ms. Powell's question. They didn't qualify due to property, and I was told they do not do penalties for the waiver program. If they aren't eligible, they can't get on that program.
Okay. What's the question about property? I'm sorry.
It was Ms. Powell. When I applied for the waiver program for a resident, they didn't qualify due to property. And I was told that they do not do penalties for the waiver program. If they aren't eligible, they can't get on that program.
Okay. Due to property, that must mean they must own acreage or they must have property somewhere. And I'm sure if they sold that property and used that money for the care of the individual until it was spent down under the $2,000, they could get on the waiver program. But a lot of people want to leave their property to family, and I understand that. It's an inheritance right, and I totally understand that.
But again, I mean, you technically could if the family could pay the lien. Am I wrong?
Well, on waivers, she's saying that there is no lien.
Okay.
Yeah, and that's what we're talking about. If you don't qualify, you don't qualify. There's no penalty, no lien. You just don't qualify. I think that's why waivers are so hard to get.
Yeah, and really the system was supposed to move to that. I mean, Medicaid waiver and home-based services were going to be the new thing, and it just seems like it has not really taken hold. Ms. Dean says there are liens for waivers, so she's apparently done that as
Good.
well.
I'm going to stop talking about waivers because I don't know what I'm talking about. Sorry about that.
It's a whole different beast, and I mean, we tried to do a CEU on it, and I mean, it's very complicated. For me, it was very complicated. I can't imagine trying to apply and get it approved. And Ms. Mink says the waiting list is so long to receive home-based services. That's so true.
Yes. It's like going into the VA home right now. There's a 6-year wait.
In Pell City, do you mean?
Yeah, Pell City, 6 years.
Wow.
Unless you're a Purple Heart winner or a Purple Heart, a clustered Navy the Airman cluster for flying. I can't remember the name of that medal with clusters. Those two move you up immediately.
Okay. Well, it's a wonderful place, and all the VA nursing homes are just so nice, such great facilities. I can see that there's a big wait, but we're sort of running out of veterans, really, from what we do. Now we're seeing Vietnam veterans who were on the older set, but there weren't as many, young men who went into the service as the generations age. So
yeah, you're right. Let's go back for just a second, talking about land and the waiver program, I'd like to ask a question if it can be answered. In the waiver program, if they sell that land, can they put that money in the Alabama Family Trust and be approved for the waiver program?
I assume you're asking Miss Dean, who
I am.
answered earlier, because I hope you're not asking me.
No, yeah, Miss Dean, if she could answer
She
that.
said every and every application comes with an estate recovery statement.
Yes.
Good question. I have been told, said Mrs. Dean. I'm not sure if maybe she's been told that that's the case, I guess.
Okay. Well, I'm going to do some major research into waivers so that I'll know more. It's just not, and in my 18 years, I've been so overwhelmed with Medicaid for nursing home, I've never even thought about doing waivers.
Cameron Connor says, I believe there is a time period wait of 5 years when transferring property in order to get on the waiver program. Ms.
Yeah,
Dean said,
5-year look back. Mhm.
waiver does impose penalties. The income resource limits are the same. They can, but have also been told they cannot, says Ms. Dean.
Okay.
So I guess there's just different information coming from Medicaid waiver program itself.
Yeah, it has to be. And I think you're right. 5-year look back is for Medicaid point blank. No matter what you're doing, you've got a 5-year look back. And so even in filing for nursing home Medicaid, if it's 61 months ago, Medicaid does not look at the 61st month. It's 60 months and forward. So that's why planning is so important. If you're going to plan, make sure you have a 5-year plan in place.
Ms. Davis says you can use the special needs trust for the waiver program. And Ms. Dean answered, I am of the belief family trust depends upon whom you speak to. I will check with an estate attorney.
Yeah, the Alabama Family Trust is a Medicaid payback trust, and it's an approved vehicle by Medicaid, so that you can get qualified sooner for the Medicaid program as far as nursing home goes. And upon death, whatever's in the Alabama Family Trust goes to pay back Medicaid for what they spent on the claimant's behalf. So I didn't know if the waivers worked the same way.
She says, Ms. Davis says it's complicated. It is a process and you would need an attorney to do it.
Okay.
And then someone had asked, Ms. Tyus had asked for your contact information, but you assumed that already happening and have placed it there. And with that, I don't see any more questions. Thank you so much for being here today again. And I believe you'll be with us again in February. Is that correct?
That's correct.
Okay, well, we look forward to that, and we'll look forward to seeing each of you again starting February 12th. We'll have Dr. Jason Newell, who's with the University of Montevallo, who will do a section on social work HB 56, which he actually co-authored. So we'll talk about both supervision and using the DSM-5T, which we've done a couple of recent CEUs on. You can check those out at YouTube if you go to YouTube and just put in the search Sean Barnes, CarePatrol. You'll see about 100 or so CEUs you can take for credit. In order to get credit for today, you'll need to go to this link. I'm going to read it now for you and then give you a password for it. It is password protected. The link is https://www.surveymonkey.com/lowercase r/ all uppercase letters F as in Frank, L, Y, 9, T as in Tom, S as in Sally, Z as in Zoo, Ms. Watkins?
There you go. You're muted.
Okay, I couldn't hear what you said about the password and the
Oh,
link.
the password is MAPS. It's all capital letters. It's Ms. Strickland's company name, which is Medicaid Application Processing Services, but the acronym is MAPS, M-A-P-S. All capital letters is the password.
Okay, and could you repeat the link again?
Yes, ma'am, I will. It's https://www.surveymonkey.com/lowercase r/ all uppercase letters, F as in Frank, L, Y, 9, T as in Tom, S as in Sally, Z as in Zoo. And the CEU password is the same as the code word, and that is MAPS.
Thank you.
Yes, ma'am. Thank you. And thank you, everyone, for being here again today. Thank you, Ms. Strickland, so much. I look forward to seeing you later this month or later in February. We'll see everyone again, hopefully on February 12th. Remember, our next Monday, the 29th, is rescheduled, and we will pick that up in March. Thank you.